of previous session, which was held on April 10, where the resource person was our very own Mr. Amit Verghese. He shared his knowledge on marriages, on the topic marriage under different personal laws. As we know, marriage is a social institution recognized by all religions. It's classified into valid, void, and voidable marriages. Marriage is usually solemnized according to provisions of personal laws. If it is in the religion, a special marriage act will be the followed. So, yeah, first we'll discuss marriages under Hindu Marriage Act 1955. Usually, Hindu religion considers marriage as a sacramental union, and the Hindu Marriage Act 1955 contains the law relating to marriage among Hindus. Section 2, I'll be mentioning some important sections only, like Section 2, Section 3, like that. So, Section 2 defines that it is applicable to all Hindus, Jain, Buddhist, and Sikh, and it is not applicable, which means marriage under Hindu Marriage Act 1955. It will be not applicable to Parsis, Jew, Christian, and Muslims. Section 3 says some definitions, which will be full blood, half blood, defines about uterine blood, sapinda relationship, like that. Full blood, which means descendant from a common ancestor by the same wife, and half blood means descendant from a common ancestor but by different wives, and uterine blood, which means descended from a common ancestors but by different husbands, and sapinda relationship is a relation which third generation in the life or line of ascent through the mother, fifth generation in the line of ascent through the father. So there is some prohibited relationship, degrees of prohibited relation, which means a relationship that is prohibited. So if one is a lineal ascendant of the other, or if one was the wife or husband of a lineal ascendant descendant of the other, or if one was a wife of the brother or of the father or mother, brother, like that relationship, very own blood relationship will be prohibited, comes under degrees of prohibited relationships. And section 5 defines on the conditions of marriage, where neither party, which says that neither party has a spouse living at the time of the marriage. Neither party should be incapable of giving valid consent due to unsoundness of mind, or should not be suffering from mental disorder making it impossible of procreation of children, should not be subject of recurrent attacks of insanity, and a legal age of marriage will be for bride's groom it will be 21 years, and for bride it will be 18 years, and should not be with prohibited degrees that we mentioned before, and there is some exception which is customer usage, and should not be sapindas of each other. Exception would be customer usage. And in Hindu Marriage Act section, in section 7, which is it says about ceremonies of marriage, that means solemnized in accordance with the customary rites and ceremonies. Saptapadi, which means the marriage becomes complete and binding when the seventh step is taken. So these are some important sections, which is it says on the Hindu Marriage Act, and now we'll go on the Muslim Marriage Act, which is, as we know, every religious community in personal matters is governed by its own law. Just as the Hindus, the Christians, Parsis, Jews are governed by their own personal laws, Muslims are also bound to follow their personal laws, which is Muslim Marriage Act, or Muslim marriage. In Arabic word, it means nikah. It's not a sacrament but a civil contract. The above we mentioned in Hindu Marriage Act, Hindu marriage it is a sacramental, but in Muslim marriage it is totally different. It will be a civil contract. Muslim marriage also permits polygamy, but it completely prohibits polyandry, and purpose of the Muslim marriage is only to procreate legitimate children. So we can understand the two acts are different, and the purpose and the ideology that says on the both marriages act are totally different. And here, the puberty must be here. Some conditions are there for Muslim marriage. Puberty must be attained, should be of a sound mind, free consent has to be there. And if there is no proof or evidence of puberty, the age of puberty is 15 years. A minor who have not attained puberty can be validly contracted in marriage by the respective guardians. Guardians can be parents, grandparents, etc. Then minor on attaining puberty is entitled to repudiate marriage at his own option. It is known as the option of puberty, Khairul Bulk. So, in Muslim Marriage Act, there will be some terms which will be difficult, some of the Arabic words, nikah, then khairul bulk, then ijab, kubul. These are some kind of words which is comprised in the Muslim Marriage Act. So yeah, no ceremony is required, and essentials of the Muslim Marriage Act will be proposal that is ijab, and acceptance means kubul in one sitting. Two witnesses are required, two male or one male and two female. Muslim men are permitted to marry Muslim, Christian or Jewish, religious, but not fire worshipper or ideal worshipper. And Muslim women is totally and completely prohibited from marrying non-Muslims. So next we'll then there is some thing about period of thing called period of iddat, which means in case of divorce 3 lunar months, in case of pregnancy till delivery, and in case of death of husband 4 months and 10 days should be there. And there is a marriage called muta marriage. Muta marriage is a temporary marriage for a fixed period of time, and it dissolves by the expiry of term. And there is some kind of a consideration in Muslim Marriage Act, which is called mahar. It is also a very important topic. Yes, so now we'll move on the Christian Marriage Act. In Christian marriage, in Christian marriage, the concept of marriage is not uniform among various religious groups, and Hindu marriage is highly religious and sacramental, that we again mentioned before, and it is monogamous. But in Muslim marriage, it is basically contractual in character and polygamous in nature. But in Christian marriages, it is highly religious and sacramental, and it is totally and truly monogamous in nature. The Christian Marriage Act 1872, which says Christian marriages are highly religious and sacramental, and Section 5 defines as persons by whom marriages are may be solemnized a person who has received episcopal ordination. And clergyman of the Church of Scotland and any minister of religion licensed under this Act of Solemnized Marriage, and marriage registrar appointed under the Act. Then Act, which means Christian Marriage Act 1872. Then Section 10 defines this time for solemnizing marriage between the hours of 6 in the morning or 7 in the evening. And Section 11 states the place of marriage, and Section 12 says about the notice of intended marriage. There is a condition says in the Section 60. Then age of marriage is again the legal marriage for all is same, that the bridegroom will be 21 years and the bride will be 18 years. Neither party has a spouse living, and marriage must be taken place in the presence of person licensed under Section 9, and at least 2 credible witnesses should be there. And moving on to the Special Marriage Act 1954. Marriage Act allows marriage irrespective of religion or faith followed by the parties. It is not considered upon the personal laws of neither Christian or Hindu Marriage Act or Muslim Marriage Act. It will be totally different from all those personal laws. it will be a Special Marriage Act. The important or the characteristic or the main speciality of the Special Marriage Act is the it will be totally based upon the irrespective of religion or faith followed by the parties. So Section 4 defines conditions of marriage. Neither party has a spouse living, as we said before in all the personal law, that neither party has a spouse living at a time of the marriage. Neither party should be incapable of giving valid consent due to unsoundness of mind, should not be suffering any mental disorder or any recurrent attacks of insanity. And again, the legal marriage is age same 21 years for the bridegroom, and bride should be 18 years, at least 18 years. Should not be with prohibited degrees. Then list of prohibited relationships are given in part 1, 2 of the first schedule. Procedure of marriage is Section 5 defines a notice of intended marriage. Notice in writing should be given to marriage officer of the district in which either of the party resided at least 30 days immediately before the notice. After the notice is published, marriage officer will hear the objections, if any, and pass orders. By virtue of Section 9 says marriage officer shall have the power of civil court, and an appeal can be filed in district court. If any appeal should be filed or have to be filed, then it can be filed in district court within 30 days, and the decision of district court shall be final. And there is nullity of marriage is stating Section 24 void marriage. It says void marriage if either party has a spouse living, if consent is invalid due to unsoundness of mind, if suffering from mental disorder, then recurrent attacks of insanity, required age is not attained, like the legal age. Bridegroom will be 21 age and the bride should be at least 18 age. So yeah, if the required age is not attained, then if the parties are in prohibited degrees of relationship, these accumulate the nullity of marriage. And Section 25 defines on voidable marriages in Special Marriage Act. If the marriage has not been consummated due to willful refusal of respondent, if wife has at the time of marriage pregnant by some other person, or if the consent is obtained by coercion or fraud. So these are the important points and sections which Mr. Amit Verghese mentioned in the previous class. So I hope all got an idea on about the previous class. So thank you.